Yep, you're audible. Oh yeah, this is recorded ya, by the way.
Yeah, okay. Okay. Wait, give me a second. Starting my speech in 3, 2, 1. Indonesia is one of the conservative country with the lack of good criminal justice system, especially in the sexual assault case. A lot of debates about what is considered as a sexual assault cases and how to prosecute it. Many cases resulted in the victim not being able to get justice in whatever happened to them. So in order to gain a better justice, we will impose the jury system or jury trial in Indonesian court for the prosecution of sexual assault cases. So what does the government mean with this? So we will apply the jury system that is similar with the US jury system, where there is filter, there's selection and background check for the jury that are going to be in the system. And also we will make it that it is the representative of the general society. So we want this debate to be the perfect jury system that represents the general society versus the judges system. So why am I going to talk in this speech? First, I'm going to talk about how the association of principle of law with the jury system. Secondly, why the jury system is better to get a better justice. And thirdly, why regardless of the progress that we can make in the status quo, in the opposition side of stuff, we can still pursue jury system in sexual case and why it is better. So first of all, the principle of the law and why it is suitable with the jury system right now. So law is something that should represent the fairness that the society believes, right? It is and not the vice versa. And not the vice versa. But right now, there's a problem in Indonesia that actually their law did not represent the fairness that society believes, because Indonesia relies a lot on the outdated law, where there's a lot of what is the interpretation of the society belief in justice and what is back then is no longer the same. And in the sexual assault cases, many sexual assault victims feel that it's hard to come out to trial because they already know that the law would not give them justice, because what they experience is not a sexual assault case in the eyes of the law, but society do know that it is a bad thing as a sexual assault case. For example, maybe if there is someone who are giving you, I'm sorry, if I'm giving you unsolicited dick pic, or maybe there is someone that touching you in the or catcalling you like in the streets and so on and so forth. As a victim, of course, we will feel uncomfortable. We will feel disgusted. We will feel that we are being sexualized and we do not deserve this, right? But in the outdated law, they're just saying that it is nothing big. Maybe this person would just get this is nothing big and maybe nothing that should be, and the end result of that does not really equate to the what is injustices, because sometimes catcalling go unpunished, giving a lot of pictures maybe that does not even go in the sphere of sexual cases. Maybe it's just in the evil and so on and so forth. But this sexual also victim does not get the fairness, right? Because the outdated law that has been going around in Indonesia. Because of this, the methodology of using the judge's trial is also outdated, because we believe that fairness should not be determined but if someone who never experienced it, like the judges, because they do not have the first-hand experience, they do not have the second-hand experience, or even if they have that, it is usually called it by the patriarchal idea, because these judges are old, right? They are all because they experience, and they are all, and they are tending to be outdated. The robot, there is more textbooks according to what it is. Meanwhile, the jury system as well, but the jury system itself, there's a possibility that this person is a representative of, there's a possibility they are already being exposed to the cases. Maybe they are going are following the cases of the sexual assault advocacy, or maybe there's a friends, or maybe they're reaching out to someone, so on, because they are the representative of the general society. And secondly, where the jury system is better to get better justice, there's a few structural reasons. First, as a jury, there are someone that is more not that robotic. They are not that textbooks, because they are more they are weighing the cases, right? They need to find facts and so on and so forth. So it means that there's a lot easier to appeal to the jury because they are the general representative society, while the judges are outdated, they are robotic, they are textbook, they are just going right. When you are applying to them, they're just going right, but the law says this, but the law says this, the law says this. No matter whatever happened to you, whatever the suffering that you're feeling, the law says this. Hence why this is the result that do not give you justice. This is why a lot of cases happen not only in the sexual assault cases. For example, the case where the court prosecute the elderly, the grandma that steal the chocolate, right? Because they need something to survive. They prosecute for 3 years of jail, where of course society say that it is not a fair prosecution for this grandma because they're just stealing a bit of chocolate and giving it 3 years in jail in comparison with a lot of cases where the the result is not that as bad as the grammar, right? So our law in court is actually positivistic, and it is hard to change because these people has been trained for years to do things like this. And meanwhile, the jury is a representative of society. They use humanitarian approach. They use feelings. They use emotions. The victims can appeal. Victims can share how they're feeling the suffering, and these things are being taken into consideration instead of just a pure written law. And also the judges in our court right now compromises of other people that is not necessarily good. What does we mean as not necessarily good? Because they're not good because they are no longer representing the society. Their value does not represent what the society believes because they are trained to represent what the law believes instead of the society believe. And for example, in the sexual assault case, what we consider as sexual assault now is different from before, right? Maybe from before it's like a rape that is physically rape and so on. I'm sorry if someone offended, but now there's a lot of interpretation of what is sexual assault. Is maybe like just catcalling is also considered as sexual assault, right? And mental harm that is considered is being taken into consideration in sexual assault case, but the judges does not understand that. That's because they are referring to the outdated written law. Meanwhile, the society do know and understand that this is something that is part of the system also and should be prosecuted fairly. And because our law cannot follow the society that fastly, cannot forget that society can also follow, but society can also follow it fast because the speed of law development is slower than society moralities then. And also this law is always outdated because the lawmaking of Indonesia is always taking a long time extra. Like there's a lot of consideration. Even in RUU PKS, there's a lot. It's been going on for years and there's no any progress, right? But regardless of the progress that we can make, for example, the RUU PKS, if the OPPO want to say about that, we can still push the jury system as sexual cases. Progress is something that is hard. We cannot rely on DPR passing on RUU PKS because they're not passing it, right? They're just telling us that it is one of the national program, and the fact that it actually being considered as national program because there's a lot of demonstration going around in the society. So if we are maybe one day becoming a lot of common, no longer doing any demonstration, what's stopping them to drop it? It means that we cannot rely on progress because it is unreliable. We cannot rely on external party that does not care and never experience this kind of things because they are again unreliable. And when if we prolonging this kind of thing, we also means that prolonging the suffering of the victim in the justice system in this is also cases. But even if the progress happens, we don't see why that jury system will hamper this progress, right? Because jury system will also refer to the written law, which means that it will be a lot better because the referring with only the law is harmful because it is just a writing, right? And the one who executes is the people. And if the judges interpret it is in the patriarchal system, it will be an asshole thing, right? Because they will just do it, will not give a better justice. But now it is a judges, you can appeal with it and emotionally and reasonably, and then they will also be more exposed. And now progress, we can also get a legal precedent of what is sexual assault and how punish it. So it can also be improved regardless we want to stay with jury trial or shift back to judges, for example, one day, because interpretation is usually from precedent and the right now interpretation is the precedent from the patriarchal society before. And for all these reasons, we are proud to propose.
All right, thank you, Prime Minister. General reminder to please be mindful of your timing. The judges will not going to wrote anything exceed 8:20. So yeah, to proceed with the debate, I call upon the leader of opposition. The floor is yours.
Right, test if I'm audible.
Yep, you're audible.
Okay, cool. Wait. Okay. I'm gonna start my speech in three. Wait, I'm gonna start my speech in 3, 2, 1. In opposition side of the house, we're going to stick to the current status quo as how our legal, like criminal justice system works, meaning that we're going to stick to our current civil law, meaning that the judge will still the one that make the judgment and also make the verdict and the sentences and what, right? But secondly, I think it's also very important to establish in this debate that things like corruptions or being bribed should not be the debate, because if the case that these judges are that dirty, for example, and whatnot, I think it could also happen on their side of the house, in which this jury could be bribed by the lawyers, for example, or people. They're going to pick like certain individuals that could easily be swayed by the rhetoric that presented by this lawyer. Right? So I think that we need to assume in the best case that both of these individuals good. But the question then becomes which metrics that should be used in judging these sexual assault cases. Before moving to my argument, several responses. One, I think the question about they talk to you on how, the textbook law, like the written law is something that is bad, therefore we should not rely on that, and therefore we should rely to these individuals like moral consciousness. But the thing that government never explained why it's something that is exclusively good when we rely to an individual moral consciousness to make a judgment to a cases that is very complicated, that has like experience like a very long time and whatnot, right? Meaning that because you need to understand that most of these individuals are just like an average reasonable persons who don't have like any experience in law, most likely they're going to be very swayed with any rhetoric that they perceive and they experience, right? Exactly, if the law is that bad, meaning that most likely these people are not going to be that aware about how to judge sexual cases, exactly because they don't have any reference on make any judgment when they're dealing with the sexual cases, right? But secondly, exactly when the law is that bad, what important is the experience of these judge. So in the absence that the written law did not provide like justice towards these victims, I think it's very important when these judges have an experience, for example, dealing with several cases, right? Meaning that they already understand the behavior of a certain alleged like sexual offenders. So it also negates the argument that these judges will be a robotic persons, given that every case is unique and therefore they have to make judgment. But third of all, I think that judge also don't want backlash from society, right? Given that most judges also want to climb the ladder of reputations as a judges, meaning that they also don't want to gain backlash from the society, especially most when their verdict is going to be made public and whatnot, right? This is exactly when the context that the law is that bad. I think that the most important thing is at least you require the basic minimum guideline on how to make judges, for example. You understand the concept of things like dolus directus, for example, or like second degree intent and whatnot. These are the things that these individuals people don't have, right? But lastly, I think it is also going to be good because the discussion will going to be great between judges as opposed to between jury, as you're going to have like a more matterful discussion. First argument, right? Why then juries, this is going to be very bad, especially in cases of like sexual assault cases, right? I think that you need to, because the thing that government never contextualize is the case of sexual cases, because this isn't the debate about like general criminal cases, but sexual cases. The unique traits of sexual cases in criminal justice system is that one, you don't have like a lot of existence of evidence, right? Most likely by the victims, right? Exactly because most of these assault happens in secluded places. It doesn't happen in a crowded places, and also don't have like a very huge evidence. You probably have very little evidence, especially things like they're probably gonna do like less physical abuse and whatnot. But secondly, exactly most of these perpetrators also likely want to delete evidence once they committing their evil act and whatnot. But third of all, exactly because the evidence are very easy to delete. For example, as comparison to when you do things like bribery or like battery or assault, which you can show the evidence of your bruises and whatnot, right? These are the things where most victims don't have the ability to obtain most of these evidence and to present it to these people, right? That is to say, exactly because the lack of evidence, like these direct evidence, the objective evidence, and these tangible evidence, it's going to be very hard for you to determine these cases, right? Because there is no direct and explicit evidence that show to your face. So most likely, what does it mean is that it requires more than just the ability to understand evidence, but the ability and the traits and the skill to understand other things aside from this evidence, things like other circumstantial evidence, for example, or to analyze the malicious intent behind a person doing these kind of things, or to understand these corroborative evidence that chained together and making into one conclusion, right? This exactly that this ability and this traits and this skills only acquired by the judges, because these are people who are experts in the field of law. Because these judges aren't just like an undergraduate students and therefore they become judge. These people have gone through years of studying academic reasons about law, for example. They're not only studying this, but they also dealt with a lot of cases in the past, for examples, right? There are a lot of dealt with a lot of precedents and whatnot, right? Most likely these people have the ability to understand like corroborative evidence. They know the difference between a first degree intent, a second degree intent. They know a circumstantial evidence, for example. These judges will ask a relevant question that most likely an average reasonable person like me, even like a law student, don't understand or don't know what to do when judging in this case, right? Therefore, this ability is something that you have to acquire through experience. That is to say, the judge have the ability to create a more objective decisions and like, eradicate most of their personal associations, because right now they're being checked and balanced with their legal value that they have experienced previously. The comparison to this jury is that you need to understand is that most of this jury is just an average reasonable person, right? Because most of these people, they don't know what to look like other hidden intent, for example. They don't understand the difference between like, the first degree intent or like second degree intent, or mostly just a surface level intent and whatnot. But secondly, exactly because in the majority of cases, a lot of these people are still not well aware with the knowledge of like sexual assault cases and how severe it is. So most likely these people are just become like an average reasonable people. Probably they're not that evil or they're not that patriarchy, but simply because they live in a conservative world and therefore they don't experience much of this knowledge about sexual cases. Second arguments about the decision, this directly responding to F case about the emotional rhetoric, that it's good because these people can buy more into emotional rhetoric rather than the right. And why then this is bad? Because you need to characterize in these sexual cases exactly when these victims are mostly women, they're minority. These people are marginalized and these individuals are oppressed in the current status quo. Most minority women that become victims of sexual assault, they don't have access to a good quality of lawyer. Most likely, they just have to rely to state-provided law, like the JPU, for example, which is probably not that good as comparison when you buy like hire an expensive lawyer. The comparison when these alleged perpetrators were mostly committed by men, that they're a majority, for example, that they have strong support groups, that the society support them and whatnot, most likely these people can afford like a very good lawyer. In most cases that you see that these perpetrators are very rich individuals. What does it tell you? It tells you that the judgment will be made by this jury are not going to be objective, exactly because when they rely to a good lawyer, they can exploit emotional rhetoric, say by this good lawyer. For example, the defendant can say, my client shouldn't be punished because he have a family, for example, he has kids, for example, and therefore his future will lose and whatnot, right? So these ability are acquired by good lawyers and whatnot, right? But secondly, exactly because the lack of evidence, jury are less likely to be convinced because most likely they only understand that in order to punish someone, there needs to be an evidence, right? But that's not the case when you're dealing with law. You have to understand like other corroborative evidence and whatnot. But third of all, exactly because the imbalance of power, that most of these good lawyers can pick like a good juries and they have their more say within the judgment in and of itself. But lastly, exactly on their side of the house, that they're going to use this similar as what in the United States, meaning that the law system and the legal system would most likely based in a binding precedents as opposed to like the textual law. We think this is exactly bad because the moment that you're going to make like one single bad decisions, this precedents will happen in the future cases and on because this one decisions will act as a future precedents and will affect future cases. Very proud to oppose.
Thank you so much for the leader of opposition. To proceed with the debate, I call upon the Deputy Prime Minister. The floor is yours.
Okay, just checking, am I audible?
Go.
Okay, going to be starting my speech in 3, 2, 1. Everything opposition just said about how sexual assault is complicated is something that opposition wants to maintain. The outcome is that this nuance makes victims unable to speak up. Victims automatically believe and are defaulted to believe that the law system is against them, that they are unable to win objectively. On government side of the house, despite our flawed, by their words, idea of using emotions, women who are victims are able to rely on something beyond just objective evidence, but they can appeal to emotions. Opposition's arguments against this: number one, you can't collect enough evidence, inexclusive. On your side, the judge will also say, guess what? The woman didn't bring enough evidence. When they say the men have good lawyers, no shit, on opposition, they have the same problem as well. And so the judge will also succumb to the better lawyers. None of these problems are exclusive. What the nuance that it is matterful, making victims unable to speak up because the victims, unless they're law students themselves, will automatically believe it's impossible. While on our side, we're trying to make a groundbreaking change. So they believe that the less intelligent and less gate kept version of juries are something that they can appeal to. That being said, let's actually respond to all of their arguments. Number one, they say that experience of the judges is good. It's better, but because even if they have knowledge, does not mean their judgment call is best. Because as my previous speaker already told you, even if they have knowledge, that knowledge is going to contribute to less cases going forward. Because we say even if you have information, it is invalid because what morality is, the definition of sexual assault, whether what consent is. When you give consent, can you take it away? The degree of sexual assault, is it verbal? Is it physical? When it is physical, is it sexual, non-sexual? All of these are really debatable, and all of the knowledge opposition relies on is on outdated information that we were previously gate kept from because we were extremely conservative. So knowledge is not an absolute way to judge these cases. Next, they talk about, oh, but the judges will be good because they don't want backlash. Number one, that's not true. It's not a democratic process to elect these judges. They have their own system. Secondly, even if it's democratic in some way, we still involve them on government side in providing the punishments, and they are also still chairing the conduct of the cases. So their incentive to make sure that the lawyers are doing their conduct well, still there. So this is not an exclusive benefit either. So when they talk about it's matterful, so the discussion between the judges are good, again, this is the barrier keeping victims from speaking up, from not only speaking up when they are part of the case, but also being an eyewitness, giving their opinions on social media, etc. So when they talk about how it is going to be objective on their side, exactly. Because it's objective, it's impossible, nearly impossible to win sexual assault cases on op because they can't gather the evidence. On our side, even if you don't get all of the evidences, you can still rely on either circumstantial evidence, you can rely on things like emotion, you can rely on appealing to the personal experience of the juries, which opposition has not responded at all, and they acknowledge that we actually have varied experiences that can discuss. It might not be the most matterful, but that's exactly why we have the jury selection system. If you're just going to rile people up, if you're either hardcore liberal radical feminist, or if you're hardcore radical conservative, you're not going to be in the jury. So discussions can still happen. That being said, let's actually continue to what we have set up on the government side of the house. So on our side of the house, what we already told you is that using these, next they talk about using precedences, this rolls into our case. So they say that, yeah, law is getting better and error pecais is going there. We say regardless of error pecais here or not, we still want the jury system, because even when they talk about precedences, the unique thing about precedences when it comes to juries is that they are not super strict. They can have a decision that lets the defendant off the hook in this case, but they have almost you can have almost the exact same case and get a decision in favor of the victim next time. The benefit here isn't to say that, well, we are going to make sure all victims are protected. Our benefit is only to make sure that there are cases where we win, while on opposition, there are very few cases where they win. So the benefit here is that on our side of the house, we can actually make sure that the discussion, whenever there is a failed case of sexual assault, a failed sexual assault case, the discussion isn't only going to be criticizing lawmakers. We're also going to be criticizing society. We're not just going to bring a nebulous principle of we have to represent society directly. Here's how we improve the discourse. When there is a failure of a sexual assault victim, when they are presenting their case, the criticism will not only be thrown at lawmakers. We will also acknowledge that the problem is that society has not been able to realize and been able to recognize the experience of these victims, which encourages more people to speak about it, to make sure that if anyone you know in any form gets involved as part of the jury, they will have this information. So people on the ground will have more incentive to openly discuss with society. Is this healthiest? Absolutely not, but it's at least there because the feminism in Indonesia has some progress. And sure, in this liberal bubble, most likely we're going to all agree. But even outside of this, we are going to make sure that we are encouraging people to have open discussions with anyone that is potentially ever going to be jury, something that is a barrier that opposition cannot achieve because their discussion can only go with judges, and judges are less likely to have these discussions with directly the feminists, etc. The conclusion to draw here is opposition has a limitation of avenues to draw to pursue when it comes to getting progress for the sexual assault victims. On our side of the house, we are actually not only able to rely on fixing these laws and codifying it, we are also trying to get to the law system via the juries themselves. But onto my quick extension, how do we make, because separate from all of this, whether we win or not, that's all contingent on individual cases. We agree with Op on that. But what we improve uniquely is how to make these sexual assault cases happen more in court and to make sure that they enter the court system rather than stay out of it. On our side of the house, we don't rely on all of the cases to succeed for society to believe in the system. Even one or a very, very few can be hope for a milestone to make sure that sexual assault victims see that there is a light in the criminal justice system. You don't need a clear 100% track record. On our side of the house, we have more cases and more discourse that happens that are going to be in favor of the victims of sexual assault. The cases being jury-based in Indonesia makes it so feminists in Indonesia, whether they're liberal or Western-based or even just Indonesian-based with less of the idea of sex positivity and more just idea of human rights, they now have a second path of supporting women in sexual assault cases because they can inform society that they have the chance of being a jury member rather than just appealing to lawmakers and judges. This is something that's progressing but cannot manifest because the people that the feminists have informed are not at all involved in the decision at all. And even if you want to go to the international route and ask for external help from NGOs or other nations, a barrier between society and the law results makes it so organizations are less likely to support you because they think whatever we do in the Indonesian system, it's still going to be based on the judges with the which the NGOs have a really, really tough time getting through. On government world, these organizations realize that people on the ground can be involved. They can support these sexual assault victims and they are able to protect these victims more directly. So if you want to make it really difficult to enter the case, to enter the court system, stay on up. But if you want to give even a fighting chance, even a bad one, just a fighting chance, go with government.
Thank you so much for the Deputy Prime Minister for that speech. To proceed with the debate, I call upon the Deputy Leader of Opposition. The floor is yours.
Hey, am I audible?
You're audible.
Okay. Some starting my speech in 3, 2, 1. Judges, I think it's populist for you guys to vote for government team. Obviously, it sounds very nice. But then again, because government's case is the prerequisite and the reason why there are more Black people in prisons in the US and more likely to be prosecuted, precisely because of white people is much more appealing to be voted not guilty, especially in any cases. There's numbers of research on how juries are more likely to be biased against people who look bad or does not fit the beauty standards or they look like a criminal. And this is precisely why in the US, Black individuals occupy majority of the prisons. There are many cases of misprosecuted individuals that is not guilty at all, but they are prosecuted anyway. This probably does not necessarily prove any kinds of equality of justice they're trying to portray. Because notice that the first people told you, oh, we want to apply jury system like the US. And this is what's going to happen in Indonesia. Separate responses. One, they told you victims don't want to speak up because they know that they're not going to win anyway objectively in the court. This is not true. Because victims not wanting to speak up, it's not because of the court, but police investigations and deterrence from the society to speak up. Those who go to court most likely have gone through police investigations. So in Indonesia, there's penyidikan, penyelidikan, and then court. So before going to court, you have to spend a lot of investigations. Deterrence does not exist because of court. Deterrence happen because of investigation. So if they argue about this, then the root cause of the issue should be solved not with changing the entire court system, but reforming investigations and police jobs or reforming the law. So arguments about deterrence are not relevant. But then there's society judgment. So why then, if the root cause of the problem is society judgment towards sexual assault victims and people who are sexually active, the solution becomes changing the entire system of the jury. We don't see the problem solution match here. There's like a huge problem solution mismatch over here. Second separate response. They told you there's a high likelihood of victims winning the case. One, we question whether or not the victim is actually a victim. I know this does not sound popular, but let's take a look at Johnny Depp's case, where there's a likelihood of a guy actually not doing the abuse, but the women doing the abuse, and so on and so forth, right? And therefore, this little example shows to you that it is not fair to diminish like these chances of objectivity just because we want victims to win. Precisely, that's the counter idea of justice and equality. So if you're trying to go with justice, then that has nothing to do with justice. But secondly, that likelihood has no certainty, because if they want to argue, oh, we have higher certainty of justice or higher certainty of winning the case, one, they have to argue why in each case specialized and how much evidence, how many proofs able to be present, visums, DNA, hotel track records will somehow then become the certainty, because there's unique cases that might be super hard to win even with juries, right? So their argument about likelihood of victims winning the case is so uncertain to begin with. I think there's a lot of evidence you need to prove against for that. Thirdly, if affirmative team wants to apply a jury trial, they need to apply the common law system. First speaker already told you about this, meaning they have to subside the common law doctrines, like decisions made by judges will be a binding precedence. They will be harmful because bad sentences by judges will result in constant bad sentences, no response at all. Even if good sentences will result in rigidity, it's bad because there's no specialized case in each individual which have specific issues, for example. Comparatively in civil law, we don't have binding precedents, so the judges have flexible to change bad decisions. They don't have to appeal to Mahkamah Agung or higher court, which is very busy and hard to do, and ensuring specificity of the case and uniqueness of the case, which makes it much more specialized to each individual without having to see other precedences with bad evidence, for example. So it's likely for the jury to follow other cases that has similar patterns, like, oh, the evidence is not enough, just vote against the victim because there's not enough judges. It's gonna still happen inside government anyway, because if it's the law that's shitty, then whatever you do with the system is gonna be bad. Fourthly, they argue that they cannot rely on parliament in progress. This is not true because RUU TPKS, or Sexual Assault Criminal Code Bill, is only prioritized in the House of Representative and Prolegnas. So I don't see why this is relevant. But they argue to you that they can use emotional, and this is the tipping point where victims can win. We argue this is not true because the education in Indonesia is extremely bad comparison to the US. Reading comprehension very low, math very low, everything is very low. So if you want to argue that people are smart enough, it's not true, because comparatively and aggregately, Indonesian individuals are less educated than Americans. Second, it's easier for judges to be juries to be swayed, and they agree. Why is this bad? It's because something can be emotionally engaging, but there's no law principles to back it up. The reason why judges is more superior in this issue is because three reasons. One, in law school, you learn about philosophy, you learn about study cases, and you learn court simulations. So you went through a lot of different scenarios in order to make the best decision. Compare this to juries, which is picked randomly, and each jury on each case is different. Like Taylor Swift can be a jury today, but not tomorrow, which means that they don't have any experiences that are habituated. More than that, judges have lesser bias against like emotional or personal biases, because they have constant reminder and doctrine in law school to separate personal view with court cases as much as possible, and becomes habituation because you study for years. Compare that to juries that are randomly picked and selected and reminded once the court will start. Sure, there will be selection, but it's different when a judge is already habituated compared to jury with a basic common knowledge because they're average reasonable person. So even if there's a symmetrical misogynist bias on jury and judges, judges have more upper hand because they are constantly told by their doctrines and peer pressured by the judges society to go against personal bias. And accountability is much better. Why? Because you have judge on your decision is questionable, other academicians can cancel you or something like that. And there is a Badan Pengawas Hakim Indonesia or judge supervisory body that can cancel you if you make decisions not based on the law objectively. So if there is a good evidence to prove enough, like hotel records of someone going to hotel and signs of abuse like blood and DNA, it's enough for these individuals to get punished, for example, for assault or sexual assault. And this is much more likely in their side of the house, in our side of the house, because judges have that upper hand and knowledge and what to do in a specific situation, especially if the case is very complex and complicated. We question why jury have the comprehension ability more upper hand than judges. They say emotional is better. That's not true, because even if judges are also emotionally engaged, they also need like objective reasoning as to why it is applicable in the principle of law, and that's why apprehend. So if they want to argue, we want people to get emotionally engaged. Judges can get emotionally engaged, but they require analysis from the lawyer and principles that juries does not need, because they only need to listen to the lawyers and like just ensure the evidence and whatnot. Much more shallow than the judges that are already presented. More than that, that means relatability is not relevant in this debate, because what is relevant is, one, whether or not you are able to judge the court accordingly to the law, and secondly, if the law is bad, then change the law, not the goddamn system. Proud to oppose.
Thank you so much for the debate leader opposition. To proceed with the debate, I call upon the government whip. The floor is yours.
Making sure that I'm properly audible.
Can you speak again?
Making sure that I'm properly audible.
Yep, you're audible.
Nice. Starting my speech in 3, 2, 1. The delta that affirmative side of the House wants to propose in this debate is on the changes that we can make in the face of de facto justice and not what the court says, right? I'm going to drop lots of rebuttals. My weighing will be intertwined, right? When they said bribery is out of the debate, yada, yada, yada. I think no, it's not. The delta is the degree of difficulties to bribe the amount of people. Because on jury system, there are lots of people, significantly more people rather than the amount of judges that is present. And B, jury is anonymous until and during the court, and while panel of judges are not. So it's much easier for lawyers to bribe judges instead of juries. Number 2, let's talk about the most important thing in this debate, right? Let's talk about what kind of justice, because what they said, no reference on sexual assault, these juries does not understand, and so on and so forth. Look, most likely juries are picked to represent the biggest demographic in Indonesian society. In our terms, it's going to be millennials, it's going to be Gen Zs, who for far too long, we are more informed than the boomers, because we have social media, we have friends, and so on and so forth. But the most important thing is B, we are shifting into a more progressive pattern. We are able to discern informations easier. We are able to criticize, even though, well, it's factually true that we are less smarter, less comprehensive than US people, but surprise, surprise, we are progressing and it's a better progress. But number three, the most important thing is that we as the generation who for far too long has been victimized by boomers, because most of the time sexual assault cases happen, what happened in our generation, because that's what is coming up to light. But most of the cases happens on a abuse of power basis, on the idea that certain boomers abusing their power to, for example, to seduce or to force us to a certain position that are out of our comfort zone, that are out of our consent. So in terms of understanding people and so on and so forth, I think that's the context, the nuance that we should understand in, right? But number three, we really like Rachel's premise. We need to proven this. I think none. And if Reinhardt wants to bring analysis on why then we can improve the law, it's going to be a late matter, because Delphi and Batara have brought to you the analysis on how law in Indonesia and the process of creation of law is extremely detached from society's perspective. Look, society for a decade at least have been progressive to an extent of understanding sexual assault beyond what can be proven in a visum, for example. Have our law updated to this? No. Have our ability to speak up and criticize the law through, for example, LBH making criticism, contrast making constant criticism on every single decision judges make, have that impact their decision? Have that impacted the law creation? No. RUU TPKS, when they said, oh, RUU TPKS is now on priority list, it has been in and out of priority list for far too long. What does this mean? This means that the fact that we can have priorities now is performative. Is the moment we silent down, the moment the demography died down, or for example, the demonstration is shifted to other issue that these policymaker in DPR shifted to another diversion, for example, Nusantara, new capital city, for example. That's the moment it's much easier for them not to discuss TPKS. It's much more easier for them not to pass the law. The delta here is simple. Relying on the process of changing the law when the process in itself is already extremely detached from the societies and society's demand is unreliable, and that is what harms them. But they try to shift this to you, right? Because they say, oh, but victim is not speaking up because of police investigation, because of social deterrence. Yada, yada. Under their set of doubts, this also happens. What is the exclusivity here? But number two, they only really think that these deterrences are deterrences because they think it's not worth pursuing and undergoing those deterrences, because once they successfully finish those, they will lose anyway on the court of law because the law are against them. That is why, at the very least, what changes under our side is the potential to actually change. This is something that is not responded at all by UGM side of the house. We wish Reinhardt would answer to this, right? But what do they say next? What if it's about Johnny Depp's case? Fun fact, Johnny Depp got there. A fun fact, this is a per case basis brought by Rachel. This is not a substitute of structural analysis. But number two, this is a good segue to my analysis, right? Because sexual assault case like Johnny Depp, by the way, fun fact, Johnny Depp has got their justice. Johnny Depp is actually uncancelled right now and has been re-platformed. Johnny Depp and other sexual assault cases, like what they said, requires de facto reverse onus, where we believe the victim first before actually proving what actually happened. This is different with any other cases where the evidence are easily presented. Since there are no objective evidence, we highly question what kind of objectivity does Mettio wants in this debate, right? Because if it's harder, because if we want to handle assault case, it's like we handle equity violation, for example. We believe in the victim first, and we actually process that and proving whether or not that actually happened or not. Those process requires reverse onus, and those process requires appeal to humanity, something that judges structurally unable to do by default, right? Because that's only possible under their jury and humanity. When they said, but there are badan pengawas hakim, there are peer-to-peer accountability. This is entirely dismissive, and this is per case basis, and there are no analysis why it's enough. Batara has explained to you that our law system is rotten to the core. The badan pengawas hakim, the peer-to-peer accountability is either unlistened to, or B, that's the same structure that condones the current law system, that condones the positivism on the interpretation of law. What's the point of having those when the law is sucks in itself? What have we proven to you? We have proven to you that we have right now the chance of justice, because right now, the moment feminist movement or the moment society can be changed, the justice can reflect this as well. The court of law can reflect this as well, because for far too long, our education, our proliferation or propaganda relies around us pushing the lawmaker to change the law. It has failed for far too long. Right now, this is our only chance to make sure that our movement can have impact, that we can the very least can create justice. That is the delta on the impact that we propose.
All right, thank you so much for Government Whip for that speech. To proceed with the debate, I call upon the opposition whip. The floor is yours.
Hello, I'm audible.
You're audible.
Yeah. Before the speech, background ko law school, so thank you. I'm gonna start my speech in 3, 2, 1. When we say bribery is out of the debate, is on the perspective of charitability. We want to protect your case affirmative. This argument is for us to be charitable because we believe the judge is more likely to be bribed and jury is more likely to be bribed. There are 3 structural reasons to this. 1, they completely ignore our analysis on the way to select the jury. Jury are selected by the attorney of both defendant and prosecutors. It means that if you have a better lawyer, if you have better attorney, in which most likely is the perpetrator, because most likely sexual assault case happens because of the power imbalance, means that you have the upper hand to choose the jury even without the bribery. But secondly, it is not expensive because you don't have to bribe everyone, right? You only need to like have 1 or 2 of your proxy to infiltrate the jury system and so on and so forth. Thirdly, it is cheap to change people's perception in Indonesia. For example, you can just pay 50 to 100,000 rupiah to change the people's voting in Indonesia, right? Therefore, we believe that it is much easier to change the jury. The fourth reason to this is there is less check and balance towards the jury. We told you that the judge have badan pengawas hakim, KPK, and so on and so forth, pointing their gun towards them. Andree told us that it's not enough, but it's still better than no check and balance at all that you have in the jury system. What does it prove to you? It proves to you that if bribery is on the account of the debate, we believe that we win on a landslide. Andree also told you that in status quo, Gen Z is dominating, but we question why Gen Z equals to liberal, especially in Indonesia, because we told you the structural reason as in the Indonesian youth are still constructed by traditional patriarchal value. The fact that they go to I'm sorry to say this, madrasah religious school that perpetuate traditional value by their parents, by their school, and so on and so forth, means that even if Gen Z like reigns, it is still a conservative types of Gen Z. But let's assume that Gen Z is progressive in their side of the house. There are 2 problems with this. One, if the Gen Z are progressive, means that the law will also be progressive. Therefore, all the criminal justice system problem that affirmative wants to say is false, right? But secondly, if the Gen Z are progressive, means that the stakeholders who check and balance the judge are also progressive. We already characterized to you that judge want to keep their image, want to keep their job as well, and therefore they also are too prone to check and balance, and therefore the Gen Z are able to check and balance the judges, and therefore the judges will also be good in affirmative best case paradigm. I'm going to talk about 3 things. One, are they representative? Because PM wants you to believe that the jury will be very representative. I have 2 let's just say 2 responses to this. One, they are not representative because the mechanism to pick the jury are are a pool of jury being picked and chosen by the attorney of both side of the defendant and prosecutor. We told you about the imbalanced position in which the sexual assault victims are actually facing, like boss and employee, working husband and housewife, and so on and so forth. Because the reason why they are quote unquote brave enough to assault to like take over the other people's dignity, because they believe that the other person do not have dignity, and this can only happen when you have an imbalance of power. This proves to you that the victims are oftentimes the most vulnerable individual, the economically disenfranchised individuals. Notice that the privileged individuals have the ability to pay for better lawyers, means that the lawyer will be able to choose a better jury that is more that will be more catering to the perpetrator itself. Therefore, actually, affirmative side of the house do not make it more representative, but rather more biased to the perpetrator itself. You actually widen the gap to be able to win in itself, right? Why judge cannot be like that? Judge have two check and balances. One, there is an internal check and balance. They understand, like they understand the knowledge of law, that you have to be equal, that you have to like see the nuance of the case, the evidences to it, and so on and so forth. But secondly, these are the people who already says the oath that you are going to judge with law and fairness. But if you cannot believe internal check and balance, you can believe the external check and balance, other judges, society, badan pengawas hukum, and so on and so forth. If affirmative wants to say, PM wants to say that they are representative because the people are experiencing, like have more experience. We question why is that likely? Because we told the judge have more experience because they have 4 years of college, judge test. They learn to judge every single day. They listen to the cases. They understand the nuance even more. The importance to this is what Mettio told you. Mettio told you that sexual assault case has a quite hard evidence to be proven. Therefore, the way for you to see that is the way for you to favor the victim is to understand the nuance of the case, the background behind the little evidence, and so on and so forth. And we believe that judge have that comprehension much better. The comparative is the jury system. At the best case, they will only see at the limited evidence and therefore make the sexual assault victim lose. But
Reinhardt, you're cut it off. Am I the only one yang nggak bisa
No,
dengar?
I'm
I cannot hear you.
doing the same thing, yeah.
We're
Alright.
trying to contact our teammate, yeah.
All right.
I think my teammate has significant internet issue because he's also not responding WhatsApp, so probably take a minute.
All right. Oh, and also Indy is going to the toilet, so we just gotta wait for Reinhardt and Indy.
Oh, Reinhardt is already online. He's going back to the Zoom.
All right.
sampai mana keputusnya?
Hello, Reinhardt. The last thing that I heard from you was something about victim blues.
Hello. Hello, am I audible now?
You're audible now. I'm clear. The last
Sorry,
thing that I heard
sampai mana
from
tadi?
the last words that I heard from you was about something about victim blues.
Victim apa? Blues.
Yeah, victim blues. Like you're talking about how like the juries will heard about the victim blues or something. So yeah, I think that was like the last word that I literally heard from you. So you can continue from that, but please wait because Indy is also going to the toilet. So we're going to wait for Indy.
Wait. Oh, okay. Menit berapa ya tadi? What was
5:41.
where was your timer? 541. Tadi udah ada soal ini belum? Judge experience gitu-gitu.
Yep.
Judge experience is representative good, itu udah oke. Udah nyampe.
I think it was around that. Kayak lo bilang what happened during the hearings. They're going to hear about the victim blues gitu-gitu pokoknya. Before that you talking about how like they have knowledge of law and whatnot.
Oh, oke. Berarti tadi udah sampai knowledge of law.
Yeah.
Oke. Oke. Got it.
Yeah.
Rain, sorry, if your bandwidth is low, I think matiin kamera.
Oh, aku udah ganti tethering kok. Tadi itu
Oh.
IndiHome-ku tiba-tiba no internet gitu. Biasalah.
Yeah, it's fine.
BTW udah balik belum ya, Kak?
India, you there? I think not yet. It's not yet.
Oke. Berarti yang internal external check and balance udah, experience udah, gitu ya?
Yeah.
Ya nggak sih? Oke, sip. Oke, cool.
All right, India is back, so you can continue your speech.
Oke. Bentar. Gonna continue my IndiHome speech in 3, 2, 1. But let's assume that affirmative accusation is correct, that representative is exclusive in their side. We believe that representative is not good because especially in Indonesia, in which you have a conservative state, the average reasonable person are traditionalists with traditional value who will blame you for your clothes, right? The comparative in our side of the house, even if the judge also came from the conservative state, at least these people have balanced out their bias to the legal knowledge and so on and so forth that they get from their education. Therefore, all affirmative benefit, including the bravery to go to court and so on and so forth, is contingent on their likelihood to win. And because we are able to prove that the percentage to win is better in NEC, we believe we win. Second issue is using feeling good. Affirmative benefit can only manifest when two parameters fulfilled. One, they are liberal, but B, the feeling can apprehend the law. One, they are not liberal, like we agree with DPM that the extreme people will not be admitted, but the average Indonesian are extreme in the US. And the religious value is prevalent, traditional value prevalent, so on and so forth, not liberal. Secondly, if the law is messed up, notice that in the context slide, they already told you that the jury will also consider it on a legal basis, and if you are innocent but your feeling says otherwise, you still cannot be prosecuted in affirmative side of the house. So if the law is messed up, symmetrical in both sides. But thirdly, bravery to come out, as what DPM told you, can only exist when there is a certainty of the law. They need to be certain if you go to the court, you are sure that KUHP, PKS, or the judge will prosecute the bad people and so on and so forth. The going to the court will not be worth it in the affirmative side of the house because it will be contingent on who the jury are, and it is using the gacha system as what DPM even considered. Therefore, we prove to you that using feeling is actually bad. But even if the people are very liberal in the affirmative best case, we believe that it is still bad because you will also allow innocent people to be prosecuted itself, right? This is why we need to have an objective judge who can weigh the two facts better to ensure no innocent people are being prosecuted, but at the same time prosecute the harmful people and so on and so forth. Therefore, we told you that using feeling is bad, even if at the best case. But lastly, how do we create better progress? If affirmative wants to say they will blame the society, it will be symmetrical because we will still blame society who like blame the clothing and so on and so forth. But secondly, they ignore the responses on the common law that the precedences will be locked in affirmative. This is why progress is better on our side of the house. Sorry for the IndiHome. Quite proud to oppose.
All right, thank you so much for the opposition for that speech. Now to open the reply section, I call upon the opposition reply first. The floor is yours.
Right. Bentar ya. Wait. Right. I'm gonna start my speech in 3, 2, 1. So here's the nuance that comes from the affirmative team. Basically, what they're trying to say is that the reason as to why like a jury-based judgment is something that is much better dealing with sexual cases in Indonesia is because the way that they frame is that dealing with sexual cases, it doesn't important whether you have the knowledge of law. It shouldn't be the metrics because the law in Indonesia is outdated and therefore we have to fully rely to the emotion itself, right? Like I don't understand why this should be the case because of course that you need to understand we have proven to you on several things, right? They never explain to you on the reasoning because we explain to you that one exactly because there is the existence on the lack of evidence within the case of sexual assaults different with other like criminal cases, for example, like assault, like battery, for example, right? Therefore you need to acquire another ability to look other than this direct evidence, which is things like, for example, like malicious intent, for example, or you have the ability to do like analysis or like link different corroborative evidence and whatnot, right? And secondly, we already have proven to you that this kind of knowledge could also be acquired when you have like certain experiences as a judge. Their only response is by saying, because one, they don't have any response like dealing with all of our these thought process. But secondly, what they're trying to say is that it all doesn't matter because this is exactly what makes like victims of sexual cases, like their cases become prolonged or they don't get justice and whatnot. And therefore, emotion is the most important metrics to judge sexual cases of like sexual assaults. The way that to respond to this is that we have respond in several reasons why relying to emotions is something that is very bad. Reason number one is when you rely to mostly to emotions, meaning that anyone, not only to the prosecutor, but the lawyers from the defendant can also exploit your emotion and your sympathy. We have proven to you in our previous speaker that things means that this lawyer can exploit the jury emotion that their client is innocent, that they are a married family, they have responsibility and whatnot, meaning there is also a possibility that this people will not be convicted guilty. But second is also very bad because there is a possibility of creating wrong verdict as stated in my second speaker. We've proven to you the examples in the case of like in the United States, how African American and most statistically most likely convicted as guilty. Or the case of Johnny Depp, for example, because he's not the one who committed these acts, never been responded by their side of the house. But thirdly, I think we'll also explain to you that the average reasonable person in Indonesia contextually is not that well educated about things like sexual cases, for example, right? At best, we've proven to you that most likely people who are educated are mostly centralized in the metropolitan area, meaning that in outskirt area, for example, like in Kabupaten and whatnot, people are not that educated. At the very least, what we have proven to you is that there is a standard education in being a judges. At least there is a standard metrics, that a standard threshold that you have to understand when you want to become a judges or when you want to graduate as a lawyer and whatnot, right? Therefore, on the idea of emotions and the idea of this fairness, we win. But secondly, I think the problem on their side of the house is that they never provide any thought process on how the judgment that will made by the civilians will look like and why it's going to be very objective, right? But third of all, I think government also have a wishy-washy characteristics because one, they said the societies are that progressive, but secondly, the law is not. While in fact, Gen Zs are the one that making the law. So I don't think this should be the case. But fourthly, I think we've already engaged in the worst case scenario. In the possibility, in the case of bribery, we have proven to you why it's something that is less likely because we've proven to you the existence of oversight body like Badan Pengawas and whatnot that constantly eyeing these judges 24/7. The comparison is to this jury is that most likely the changes every time there are different people and whatnot. So therefore, affirmative need to explain why there is a model or the existence to oversight most of this jury. Like even if they want to bring it on their reply speech, I think it's very late, right? So therefore, judges like. I know that team opposition is like not the most populist because to some extent we still defend individuals who are not directly committing this case. But I think that the reason is why people want to come in law, the certainty is if that law provide like the certainty of law to begin with. And that's exactly what Andree provide. Very proud to post.
Thank you so much for the question reply. Last but not least, I call upon the government reply. The floor is yours.
Okay. Just checking. Am I audible?
You're audible.
Okay, thank you. Gonna be starting my speech in three, two, one. Opposition only wants to engage in scenarios where no jury trials deliver a verdict in favor of the plaintiff. Government has engaged beyond this. Check your notes to see if op has given attempt to this. Opposition talks about changing the law, not the system, with no attempt to back this up. I think my government whip called this out, and opposition never really ended stepping up to this challenge. When opposition keeps relying on this idea of experience, we already told you it is not just law experience that's important in this debate, but it's also with sexual assault. What it is, what it involves, how the victim feels, etc. We never denied that judges have more law info, but it's bad info. But juries have more experience on the things involving sexual assault and what it looks like. So quickly, two metrics of this debate. Number one, certainty is just a plain terrible metric. Both sides are fighting an uphill battle. It's on the marginal cases and who can gain marginal benefits. Number two, how to improve the discourse and support for sexual assault victims, something more definite because it's something that's happening in society. Crucial problems with opponent case. Hard to get evidence, good lawyers, and the investigation process is something that victims are afraid of. Plain and exclusive. All of these problems are not solved on opposition, so it's not our burden to do so. But secondly, we engage with this, saying that all of these could be mitigated via emotions, something that they admit could be overtaken. Because even if you don't have the best lawyers, you can use emotions. They admit to that. Second, when they say, oh, society is then the problem, we shouldn't change the system, opposition again still doesn't solve this. Only a very small point in their upwave speech saying you still call out people who are victim blaming, but no substantive beyond that. So secondly, they talk about how judges are much more exclusively informed and have more experience. No analysis why this information is good. It's still biased against the victims because that's what they know. They'll be better at justifying their decisions, sure, from a law perspective, but is that decision good? No. Even if they say that our side has bad jury selection system, all of the substantive of how this can get that bad comes from upwhip, so it's quite late. But even then, our case is not reliant on having a good track record. We were willing to explain why in the few cases we win, we're good with that and we get the benefits that we are promising. When Op says, oh, the common law thing sets up bad precedences. We engaged with this. We told you that opposition side has precedences as well, but government side has these precedences, but are able to overturn them because juries are not entirely reliant on these precedences, while judges are super reliant on these precedences. When Op says there are wrong cases, Johnny Depp, etc., judge, really, if I point to the endless amount of cases where victims are definitely in the right, but they were not given justice, does that mean government win? Nothing is definite from up here. I can also throw an endless amount of examples. That's not really something that you should judge in this debate. What are then our most important cases from Gov that makes us win this debate? Number one, the urgency to provide fairness with proper timing and ability to adapt to what society deems the definition of sexual assault, consent, etc. is. No engagement on the outdated aspect of the knowledge that these judges have. We want to be fair and not be determined by a select few that's either never experienced sexual assault, never have experienced secondhand experience, and even if they have secondhand experience, it's often outweighed by their overall view of it. So despite some exposure to sexual experience, these judges are not that good. Important thing here, the process of lawmaking and decision of law is gate-kept, not adaptive, and something that opposition never was able to explain why it's going to be that progressive. Where opposition says, well, and lastly, they say a case where the victim wins can still happen on up. So the benefit of encouraging people to come out can happen. We already engaged beyond this, that we are much better because we are giving victims and advocates of victims more ways to gain justice and positively affect the results. Something that regardless of the law progress is an absolute good because they now have access to law decisions rather than relying on only advocating to lawmakers. Why should we win? Two reasons. One, the outcome is in no way definite. Op has information, but no incentive to make sure that information is used to protect the victims. Gov has not given a definite outcome because we know it's difficult, but we're willing to engage saying despite only some cases succeeding, it is good enough. Opposition only engage in the scenario where it's very bad. And lastly, even if it's bad precedents, we engage with all of this as well. For all those reasons, regardless of the outcome, very great debate.
Thank you so much for the government reply for its speech, and that's the overall debate. Both of the teams can virtually shake your hand with each other, or if you're close in proximity, can also like shake hands physically. But yeah, you can leave the room, both the debaters and also observers. So the judges can collecting the result.